Education laws in Alaska. There are three main documents to Alaska's education laws: the Alaska Constitution, Article 7, Health, Education, and Welfare. In this article, there is the Education Clause and Supreme Court cases that end up clarifying the Education Clause. The Alaska State Statutes, Title 14, Education, Libraries, and Museums, sets up expectations for public schools, charter schools, and correspondence programs. They establish student privacy, student discipline, anti-discrimination and equal opportunity laws, privacy rights of teachers and school personnel, as well as tenure and dismissal laws. The third document is Alaska's compilation of school discipline laws and regulations. This specifies procedures for student discipline in school. The first law we'll be looking at is the Alaska State Constitution, Article 7, the Education Clause. Section 1 states that the legislature shall, by general law, establish and maintain a system of public schools open to all children of the state, and may provide for other public educational institutions. Schools and institutions so established shall be free from sectarian control. No money shall be paid from public funds for the direct benefit of any religious or other private educational institution. This is the most unique and controversial law of Alaska in regards to education. The Education Clause requires that the legislature establish and maintain a system of public schools open to all children in the state. Macaulay v. Hildebrand in 1971, the Supreme Court affirms that the state is constitutionally mandated to establish and maintain the school system. Alaska at this point in time had a system of boarding schools for Native students, and some students would even have to go as far as out of state to attend a school. In Breeze v. the State in 1972, it affirmed that Alaska students have the fundamental right to receive a public education. This led to the Molly Hooch case versus the Alaska state-operated school system in 1975. While the Constitution did not require uniformity in the school system, it did state that all options of school must be available to all students. That includes boarding schools, correspondence programs, and other programs such as public schools. Students had to go far for public schools in their region, oftentimes leaving their family and communities behind. Because of Molly Hooch, it was established that public schools had to be built in Alaska Native rural communities so that children did not need to leave their homes for school. This made the government provide funding to build schools in even the smallest of communities, with there being schools with enrollments of only 10 students. With villages being so remote and having some with such small enrollment, this led to Kasuli versus State, in regards to arguing that the state was discriminating in funding to construction of rural schools. The state favored urban schools because their enrollment was higher and there was a debt reimbursement program, while rural schools had no such program and had to wait for legislative approval since Alaska has no state taxes or local taxes. This case ruled that Alaska violated its own Education Clause and the Equal Protection Clause and the federal civil rights law, which led to more funding for rural schools. Similar to this, Moore v. State also fought the Education Clause. They claimed that the state wasn't providing an adequate education to rural schools. This is in regards to funding, standards, assessment, and oversight. The Supreme Court ruled that Alaska violated the Education Clause, and it ordered additional oversight and assistance to these rural schools so that Alaska Natives had more of an equal opportunity. The second document that we need to look at are the Alaska State Statutes, Title 14, Education, Libraries, and Museums. Title 14 sets up expectations for public schools, charter schools, and correspondence programs. It outlines student privacy laws, student discipline laws, anti-discrimination and equal opportunity, privacy rights of teachers and school personnel, and tenure and dismissal laws. Student privacy laws in Alaska include search and seizure, the search of school lockers, where a locker provided by the school and the school district may be searched and examined with permission of the school administrator. A search may not be more intrusive than reasonably necessary to meet the objectives, and there must be notices in letters and in signs on walls stating that the right and intention of school and the school district permit the searches and examinations of school lockers. The privacy laws for students in regard to school records are that all parents of kids under the age of 18 must be provided a copy of their child's records. Student discipline laws in regards to weapons in Title 14 require that there must be at least 1 year suspension of a student who possesses a firearm and at least 30-day suspension or expulsion for students who come to school with a deadly weapon other than a firearm. Granted, there are rural communities where this is a case-by-case basis due to rural communities and subsistence being a way of life. In regards to absenteeism and truancy, Alaska has a compulsory education law where students between ages 7 and 16 must attend school. The penalties for parents for noncompliance to this law are up to $300 fine, and every 5 days they get another $300. It is up to schools to come up with their solutions for how to reduce truancy in schools. In regard to bullying and harassment, each school district shall adopt a policy that prohibits any bullying, harassment, and intimidation, and this policy must be shared with the public and all employees, as well as the state. Corporal punishment is illegal in Alaska. It has been prohibited since 1989. Alaska's policy on anti-discrimination and equal opportunity prohibits against discrimination based on sex or race in public education. The Coalition for Education Equity in Alaska is an organization in Alaska that advocates for education reform. This organization fought and settled Kesayuli and more lawsuits to remedy unfair distribution of education resources. Under Title 14, it also establishes privacy rights of teachers and school personnel. It is a teacher's right to comment and criticize and not be restricted by the school. It is also unlawful for employers to require a statement of religious or political affiliation. Teachers' rights in regards to tenure and dismissal mean that teachers cannot be fired unless it is due to incompetency, immorality, a substantial noncompliance of school and state laws and regulations, a violation of ethical or professional standards, or contractual obligations. The state also has the right to revoke the teaching certificate if a person has been convicted of a crime. To get tenure in Alaska, you must be an employee for 3 years, and the tenure rights give you the right to employment within the district as long as it's during your service. As well as, there must be a notification of layoff or non-retention for tenured and non-tenured teachers before May 15th, and it must be in writing. I found the laws and references for this slideshow in the Alaska Constitution, the Alaska State Statutes, Coalition for Education Equity of Alaska website, Alaska Education Laws, FindLaw.com, in Alaska's State Constitution, A Citizen's Guide, and in The compilation of Alaska school discipline laws and regulations.